Just President Hlophe, thanks again for talking to us at Ngalwana Law. One final issue in this segment is an open-ended question. Is there anything that we haven't covered about which you feel you want to share with the public?
Yes, Mr. Ngalwana. One of the things I would like to see, and especially if I get the job of a Chief Justice, it is to have the two courts, the Constitutional Court and the Supreme Court of Appeal, amalgamated. You need one superior court, right, which will be headed by the Chief Justice. That court will be located, I believe, the Constitutional Court is big enough to locate that court. It has parking in abundance, or they can build more buildings if necessary, but in terms of the venue. So that you have one Chief Justice, and then if there is a case of constitutional importance, the Chief Justice would take 11 judges out of the judges in that court and sit with them. And that court can be busy and hear other matters. That's just one change I would like to introduce. I know there was a lot of debate around that issue, but I think the time has come now to pool our resources together.
But why do you think that hasn't happened?
Well, I know for a fact that the judges of the Constitutional Court 15, 20 years back, certainly these were the views of some of them, they felt that they were appointed by a democratic government, and they went straight, a lot of them, to the Constitutional Court. They did not serve as judges in the Supreme Court of Appeal. Whereas judges in the SCA, we have already said that they refuse, for instance, to go and give evidence before the TRC, and I think it was just politics between the two courts, right? I am also aware of the fact that at that time the debate was very much pronounced. At that time, the head of the Constitutional Court was called the President of the Constitutional Court. It was Charles Carlson. Then the terminology was changed because Charles Carlson quite rightly felt that you can't have the Chief Justice located in the Supreme Court of Appeal, but further appeals from that court go to the Constitutional Court, and that court is headed by the President. Then there was an amendment to the Constitution that was dropped, the terminology was changed. In short, I would like to see those courts amalgamated into one. We would save so much money, in my view, right? There will be one apex court. The other thing that I'm not happy about, again, I'm talking subject to correction. This whole provision in the Constitution which allows direct access to the Constitutional Court, I have a problem with that. Because you have a situation we have seen in some cases where a matter is pending before the High Court, and the practitioners, for one reason or the other, ignore what is happening before the High Court. They rush straight to the Constitutional Court. If I remember well, I'm speaking subject to correction, that provision was introduced because High Court judges at that time had no testing right. In other words, we could not declare an act of parliament invalid because it was unconstitutional. With the current constitution, which is the final constitution, we have a testing right. If an act of parliament is unconstitutional or a section thereof, a judge can say section 7 of this act is unconstitutional. It flies in the face of a particular clause in the Constitution. And of course, a declaration of invalidity does not kick in until it has been confirmed by the Constitutional Court. I have serious problems with the right of direct access to the Constitutional Court, especially because that is the highest court in the land. So where practitioners have rushed to that court and there is a pronouncement made by that court, it's the highest court in the land. An aggrieved litigant may wish to appeal against that, and the right to appeal is no more because you have an apex court which has entertained a matter which otherwise belongs to a provincial division. From a provincial division, it should go to the SCA and ultimately to the Constitutional Court. So that's just one provision that I would like to see change so that there's no direct access to the Constitutional Court.
No direct access at all. What about constitutionally urgent matters?
Constitutionally urgent matters, we can change the Constitution. For me, the Constitutional Court would derive a lot of benefit in terms of if the matter were to start in the High Court. For instance, nothing stops the Constitution from being amended to say where allegations of gross constitutional invalidity have been made, the matter must go to the High Court, the full bench. The judge president of that division shall immediately convene a full bench, and the appeal thereto may lie to the SCA. We can have truncated procedures, but I think the court, with all due respect, would learn a lot from where a matter were to start, or litigation to start in the High Court before it goes straight. I've already given a reason. Once you do that, the litigant who is aggrieved by the order of the final court has nowhere to turn to. We've seen some strange judgments, right? I prefer not to mention cases, but we have seen instances where parties rush to the Constitutional Court, there's a pronouncement by that Constitutional Court, and an aggrieved litigant has nowhere to turn to because the highest court in the land has pronounced. Where do you go? African Court for Human Rights? We can appeal to the Privy Council. The right to appeal is no more. So I think based on the hierarchy of the judiciary, for me, the starting point must be the High Court. We are always here as judges. There are always 3 judges or 2 judges on duty here. If there is an urgent court point relating to constitutional law, nothing stops at JP. All of us are 24 hours on duty. You put together a bench, the law, the time frame can be truncated. We can agree that in terms of the Constitution, where allegations of constitutional invalidity are raised, you go to the High Court. Within 7 days, or whatever, the judges will make a ruling or give reasons. Thereafter, you may appeal or whatever. But we need to respect the High Courts and give them the benefit of pronouncing on those matters to avoid a situation whereby an aggrieved litigant suddenly has nowhere to go because the highest court in the land, without the benefit of the High Court and the SCA, has made a pronouncement.
All right. Final question. In your racism report of, I think, 2004,
yes,
you set out a litany of problems on the bench on the relationship you had with white colleagues and so on, and the experiences of black judges in general when dealing with their white colleagues and with legal practitioners, particularly
yes,
senior legal practitioners at this division or in the bar here in Cape Town. How would you now, on the 18th of October 2021, describe firstly your relationship as Judge President of the Western Cape High Court with your colleagues in general and white colleagues in particular? And secondly, your relationship as Judge President with practitioners in this division generally and white practitioners in general.
All right, let's start with my colleagues. We have had a fair share of our problems, but they are not unique to us. I get on well with colleagues purely at the level of working with them. I treat them with respect, I allocate work, I am not vindictive. There is not a single person who can say when I greet him or when she greets me, I pull my face. So I have a cordial relationship with my colleagues, even those who may not like me. I'm not here to be liked by colleagues, but I'm here to ensure that the doors of this court are open and that everybody does his or her work. Right? This includes white colleagues, those who are retired, who have retired, and those who are still on the bench. Right? In terms of my relationship with the bar, I prefer a very professional relationship with the bar. I said that to Mr. Stelzner, who is now president of the bar. I said, look, let's have a very professional relationship. I prefer it like that. I have white friends at the bar. I hunt with them, I spend time with them, but not everybody at the bar is my friend. Like I have black friends in the black community. I We play together, we do whatever needs to be done as human beings. We attend funerals together, we go to church or the mosque as the case may be, but not every black practitioner is my friend. In short, I have friends at the bar, both white and black. Just like on the bench, I have friends, very close friends, who are white, close to me, and who are both black and white. Obviously, we've had our fair share of negative publicity, but it's not confined to this court. We've seen it in other courts. And to differ is human. My role is just to make sure that the doors of this court are open. Nobody must feel victimized, or nobody must feel that he or she is forced to be my friend. I have a very cordial relationship with everyone that I come across because I treat everybody with respect in a very cordial manner.
So the professional relationship between the judge president of the Western Cape High Court and the other judges is as it should be.
In my view, it is exactly as it should be, neither more nor less. It should be like that, and quite frankly, we should treat our colleagues with courtesy and respect. And if the relationship ripens into a friendship, so be it. We'll have braais together, we'll go to church together, we'll go to the mosque together, we'll go and hunt together, we'll go and run together, those of us who are running. There is nothing wrong with that.
But in your report, the racism report, you mentioned that you stopped attending the annual dinner of the bar.
Yes.
Do you now attend the annual dinner?
Well, I have not attended the annual dinner. After that, I stopped for about 6, 7, 8 years, and then I attended dinners. For instance, when Tabani Masuku got silk, I was there. I regarded him as my candidate. When Uputumi Nsebeza got silk at the Table Bay Hotel, I was there. In 2017, 2018, there were 4 judges were appointed here. Cheswell Pepia, who came earlier, Derek Vila, Mark Shea, and somebody else, I'm forgetting the 4th judge. I was there together with my wife in 2017, 2018. That was the last bar dinner which I attended. 2019, there was no bar dinner to the best of my knowledge because of coronavirus. 2020, there was no bar dinner, and this year, I don't think there will be a bar dinner. But I have a very cordial relationship with the bar. For instance, you know there is PEEC, this is Provincial Enhancement Committee. Members of the bar, without any exception, always attend that. Mr. Stelzner, who is the leader of the bar, always attends and he makes valuable input. Maybe it has to do with the leadership. Again, when I had Louise Bateman SC, a lady, the gap between my office and her office, we breached it so much.
You what? Breached?
Yes, it was breached in the sense that prior to that, perhaps there was open hostility, as it were. But largely due to her personality, we became relatively close. And the working relationship between us improved immensely. It had to do, I think, with her personality.
Okay, well, that's encouraging because there should be a cordial relationship between the bar and the bench. Otherwise, things go helter-skelter.
No, I agree entirely. And then if you look at judges and the acting judges here, there's a fair number of them who come from the bar, especially women. There's a fair number of them, especially women.
Right. Judge President Hlophe, thank you very much for affording us this opportunity to share in your life's journey to the extent that we could cover it in this limited time.
Thank you very much.